It's good to be back and in the same room. How are you going?
I'm good. We actually just offline, we were talking about how the world became smaller during lockdown. How I started thinking about, well, what will I cook this night and where will I go and find it? But I had my family boys' night out to dinner together the other night, including my young nephew Marcus, who's sort of 13. It was just lovely, just being out.
Yeah, I haven't had that chance just quite yet.
No.
I'm still here. I think lockdown 5 really kind of was very hard for me personally, but I'm just really happy to be outside of home.
And what about Soph putting together that song list for our Sydney team?
No, that's great.
Yeah, so the lockdown songs. And what was Matt? Nutbush City Limits.
The Nutbush, yeah.
I just spun out Rock Lobster and Karen's never heard it. Anyway, look, I think we should probably move on beyond that. We've got a pretty interesting week this week. Once again, that sort of crossover between safety law and workplace law. And we're going to come back, answer a few questions from last week that were raised. I'm pretty excited about today's agenda. It's, again, nothing magical about the law, but some cases which really illustrate the types of things that you and I struggle with every day. By the way, if I can just thank everybody in relation to the CEO poll survey we did. I think most of you probably have got a copy of an amazing amount of feedback we got.
Yeah, very positive.
And then a terrific uptake. So the click searches, whatever that means. No, the click searches were really high, which shows not only did we get a lot of help from you, but I hope we delivered some content that you were interested in, which is great. And in the next couple of weeks, Karen and I will be putting together another one to deal specifically with not COVID, but with the nature of the relationship that people in HR and OHS have, navigating the role of being a leader and reporting up, but working downwards as well. And what is that like, and what are the pressures that has? Because I think we see some excellent HR and OHS practitioners who work for us and manage to keep that divide working well by keeping the authority of being an influencer and a provider of resources, but equally provide the glue that keeps an organisation together and feel loved, cared for, respected, and building capability. It's a hell of a challenge.
It's a lot to work with, and as a result, there's a terminology or a concept called the toxic handler, which we'll cover off as well. Yeah,
that's right. That's interesting, isn't it? Okay, well, look, let's jump into this week. First case I want to talk to you is a case called McNamara and Aero Pacific. A really good case in the sense that this was a guy who was driving a vehicle carrying a 10-metre I-beam, steel I-beam. He had to reverse up a driveway. He'd done it once before with a supervisor, needed to because there were power lines above. And the director, who was a fairly unsophisticated director, demanded he do it on his own. And he said, look, it's too dangerous. I'm not going to do it on my own. The director abused him and then terminated his employment. Subsequently, when he realised he'd gone too far, offered him back, but on probation. The matter went as an adverse action, and what was the workplace right? He'd raised a safety concern, so a workplace right includes a right protected and enshrined in workplace law, and he'd been terminated as a result and then offered a lesser job. And of course, the court had no difficulty at all in finding there was adverse action and awarding a substantial amount of compensation. But I guess for Karen and I, this is just such a familiar case where people raise. Now, can I just go back, 6 or 7 years ago, the Patrick Stevedore and WorkSafe case is one where it was a union official, and the union official made a complaint through to WorkSafe. So they followed the dispute resolution process. WorkSafe prosecuted, and this was where the union delegate was working, and they're picking up steel rods, and he said, look, the bundling of the rods is too dangerous to pick up. It should be done in a better way. They did a phony risk assessment that said they were doing the right thing. He said, look, anyone looking at that knows that's dangerous. WorkSafe said it's dangerous, and they prosecuted Patrick Stevedore for $180,000, and that went all the way to the full court appeal. I just want people to know we're very, very lucky. This employer was very, very lucky they went through adverse action, not through a prosecution. Because what they did deserved prosecution. But Karen, what should they have done?
Well, some would say that you'd need to run a safety investigation, which really, I think the proper terminology for that would be to run a risk assessment. Thinking, why would you call it a safety investigation? Anyway, so the risk here is that people need to understand that it is easier to raise a complaint or an inquiry around safety than it would be, I find, under employment law or workplace law. So let's accept that hazards and the risks associated with hazards are real and they're present and they're there all the time. So you need to actively manage that rather than, than not, and then wait for something like this to happen. So I think the lesson from this, Andrew, for me, is that understand that safety is not something that you can just put to a side. You have to actively manage it. And with risk assessments, hazard management, and going through that whole hazard management cycle.
Isn't it funny, though, that people assume that when someone raises a safety issue, they're doing it because they want to get out of work? I don't know how often this has been raised with me, but the truth is that people who work on the floor with their hands, particularly, commonly know what risks are. And they commonly don't raise them and wear them because their job is to get the job done and they're inclined to. And Australians are the worst at doing this. They take incredible risk for their employer. But when someone raises a risk, the first thing you have to do is undertake a risk assessment. You must do it because the person said, look, I perceive this risk. Now, that risk assessment can be relatively rudimentary if it's very obvious, but you still stop and go, okay, well, let's have a look. You've got to go up this. They had to reverse up this steep, windy hill with a 10-metre I-band.
But the issue is this, Andrew. Why are we even there? Why wasn't this identified previously?
Oh, of course.
Do you know what I mean? Like, this is what I'm saying. That's why my whole point is around, well, if you're managing safety properly and you're treating it as an absolute priority and as part of your business, this would be happening.
But this is just dumb and dumber, isn't it? Like it is, and all I want to say is things have gone very quiet because of COVID at a regulator level. So we haven't seen many prosecutions come up. This case came up in Victoria and New South Wales. It was complained about to WorkSafe. This wouldn't be an infringement though. This would be a prosecution because it was so dumb. Anyway, good case. Good case. Next one, Safe Work New South Wales and Rex and Wang. Now, this is a case, we're doing dumb and dumber cases today.
Okay. I've got something to say on this one too, but I'll let you.
Because this is dumb and dumber. This was the moving of glass panels on forklift. And the director thought it would be a good idea because they were a bit unstable for someone to walk with the forklift, stabilising the panels. It's hard to envisage anyone thinking that's a good idea, but nonetheless, that was the clever idea. Before that, they didn't have that, and it was safer. You won't be surprised to know that Rex, which is the company, and Wang were both prosecuted. Wang got $45,000 fines, $200,000 plus for the company. But none of that really matters. What's really important is that WorkSafe New South Wales, Safe Work New South Wales, WorkSafe here in Victoria and all other jurisdictions, all of them have guidance material around portable machinery like forklifts. And the reason I'm telling you this is there is a primary test about what is a hazard as a matter of law. And the hazard is to determine if there is a hazard, how is it imputed to the knowledge of an employer or a PCBU, depending where you are, that knowledge, how does it know? And do officers have that knowledge? Well, yes, in the model states, officers have that knowledge as well. In Victoria, you have to show that it's brought home to that officer. It would be brought home to the officer if there were published materials about it in Victoria. Those published materials identify within an industry where you use a forklift that the utilisation of a forklift outside of the criteria designed within those published materials on safe use is a hazard. Therefore, you can never say, remember, reasonable practicability has 4 elements. Is there a hazard? What is the risk that attaches to that hazard? What is the control that applies and how to use resources? This case died as soon as it was a hazard, because at that stage, the published materials show what is the nature of the risk involved and how it ought to be controlled. And in this case, none of it was done. Now, in I think it's section 22C of the Victorian, it's section 27 of the model legislation, you are entitled in the court and you are entitled to take into consideration those published materials as evidence of reasonable practicability. And in this case, Mr. Wang didn't know any of those materials, didn't comply with any of those materials, and designed a process that was inherently dangerous and could kill someone. He's very lucky to get out without reckless endangerment. Over you, Karen, because you've got some things to say on it.
Yeah, and opening up with my long sigh. Anyway, look, the thing here is that with the forklifts and with traffic management, that is a well-established critical risk. If your business involves any type of that activity, it is a critical risk. You need to manage it very, very closely. In terms of, as a result of it being a critical risk, whether it's Safe Work Australia, WorkSafe, there's publications, there's resources made available to setting out really clearly what these hazard sources are, what the risks are, and God forbid, what the controls are as well, in terms of what is recommended. So there's no excuse whatsoever, whether you're starting a new business, a one-person business, or a large, global business. This stuff is accessible to everybody. It is free, so there's no excuse whatsoever. So that's really, it's just, he should have known, and there was really no excuse for it. And he is required to do. It's just such a dumb case. I'm beyond words.
Well, that's which I chose the case. It was the dumbest case of the week, actually.
He did it just to stir me up.
But it's true. Had somebody been injured, badly injured in this process, and there was somebody who was injured, but really badly injured. Had this happened in Victoria, there is absolutely no doubt there would have been a reckless endangerment charge.
Yeah.
Okay, because the risk was known. There was an indifference as to the risk. And somebody was seriously injured. That's reckless endangerment. Let's go to jail.
Yeah, and look, I'll tone it down a little bit. For those who actually don't
know. Why spoil it? We're just starting to head up. We've got more things to go.
I'll be sensible about it, right? But for those who don't know and are new to this industry, let's say, so you're a director, it's not a place you've been involved in before, but you're involved in the business. The thing is that you need to, this makes it really, the materials that are available there, I guess I just want to say that it makes it, you find out what the unknown is. Yeah, you don't know what you don't know. But here we have right in front of you material or resources that make that very clear.
And they're published by the regulator.
Yeah. Well,
anyway. It's like going to school and not doing your homework, really. Yeah. Okay, well, look, there's a few questions last week. We're moving on. Okay,
we are.
Vicky Martin asked us last week when we were talking about the workers' comp, the Section 41 declaration, is it okay if it's in the contract? And the answer is, Vicky, yeah, it's okay if it's in the contract. The problem is that often offers are made and accepted and the contract's not real. I don't know how to explain that any better, but an offer and acceptance is what a contract is. So if I say to Karen, you come to work to me, I'm going to pay you X, and Karen says yes, and I send out the contract and Karen signs the contract is completely invalid. The contract is the oral contract that Karen and I had, and then the court fills in the reasonable terms, okay? So if you've got a very good process, it's great, but best practice is always to get a stat deck because it draws home attention to that particular issue. That's what Alison told was about, Vicky. It said, unless you say, and I'm very, very clear, that a failure to disclose your health-related circumstances as it relates to the inherent requirements of the job will lead to the termination of your employment. The stat deck creates that by saying it's committing a crime if you don't, then it won't be effective. So the stat deck is a more effective method than the contract. The contract's okay, and it's a place you can go, but your insurer is not going to love you for the contract, one, and the termination process of the person's been there a year or so will be more complex, whereas the stat deck will always be actionable. Yeah. We've got two anonymous questions, and we don't know who anonymous is, but I like it. When an organisation reviews the existing position description, is employee consultation required? The answer is, if they're an award-based employee, absolutely, because it is a major change, because you're changing the nature of the role. And at common law, the changing the nature of a role is a termination of employment. Okay, now your contract will say to undertake the work in the position description tab in such reasonable jobs as are required from time to time or as reviewed in your position description. That really doesn't go terribly well when you end up in a contract jurisdiction like the Victorian or New South Wales Supreme Court. So when you go to vary PD, you reissue the PD, usually around the time of a change in remuneration, and that is the job. Okay, be really careful about it. What are the key considerations to ensure an effective PD? And Karen, I'm going to throw to you at that stage.
Yeah, okay, great. Well, Sophie, have you got a slide for me?
I think she's still putting the playlist together, I've got to say. No, there she goes. Well done.
Well, okay, so this is making its way to you if you haven't already received it this morning. So I've put in here the 5 elements. Now, there can be other elements to it as well, but I've called out the 5 main areas for you. Make sure you get your PD. First of all, summarises really clearly what the title and who it reports to, and in terms of banding and location. The purpose of the role is really important. Always really nice to have a strong one-liner to explain that. A bit about the organisation in terms of profile, but also the function's purpose, visions and values. That's where you put this. This is very important, particularly with your values piece, because ordinarily that wouldn't be in the employment contract, but normally captured here, Andrew. Responsibilities, so we're talking about tasks and duties, and try and list them in terms of your most high frequency or your most critical task and responsibilities at the top. Work your way down. Mention in terms of if there are key stakeholder relationships that need to be well maintained, that this is really important to put in here also, rather than just transactional tasks. And also the requirement to perform other work as well. So in terms of keeping that scope, in terms of the PD provides a great a guidance document, but it can people can perform work outside of that where it's relevant and where they're trained to do so. Skills, experience and qualifications, that's pretty straightforward, but the one I really want to draw your attention to here is around the psychological profile. We spoke last week, Andrew, around the need to really consider what the environmental factors in terms of the jobs and the demands and the pressure and the dynamics of that type of work and that work environment, and how that needs to be considered when you're selecting or recruiting for this role. So for example, if it's a startup business, and I'll use that because that's normally very lean in terms of resources, normally very quick in pace. It can be quite high pressure. The hours can be a bit all over the place. That if you hired somebody, let's say in a business development role in that type of business versus a business that's well established and is well structured and well resourced, 2 completely different roles, right? So think about that in terms of what type of person, in terms of what traits and profile they'll have, and that includes even things around the emotional awareness, situational awareness, EQ, all that stuff. That's where that's factored in, okay? And the last bit there, just around additional requirements, just consider the safety aspects of the work and physical aspects to be able to perform the work safely. Additional conditions as well around whether it's weekend work, peak periods, peak hours, seasonal work, but also other relevant environmental factors as well. So, whether people are working outdoors or in kind of different, or I guess extraordinary or unusual kind of locations. But the key points for me here, guys, for you to take away is, remember, focus on the role, not the person. Make it easy as a document for you and for the users to read and to understand. Review it periodically to make sure that it is relevant and it's accurate. And the last thing is use it, because often with PDs, you write them and they get slotted away and you don't refer to them.
This is your major performance management.
Absolutely. Yeah.
But Karen, we are running a bit of time because we got a bit excited by the safety case. You've done a bit of research about
yes.
How reliable CVs are and the level of honesty involved in it. Do you want to just give us 1 minute on it?
Yeah, sure. 30 seconds. 40 to 50% of CVs or resumes often are inaccurate. So on that basis, that's problematic, because essentially that's people willingly misrepresenting themselves, and essentially that's serious, Andrew, because that's lying. And
so what we're going to do next week, with your permission, because I'm just dropping on it, is we're going to take you through the process of recruitment. What are the risks in recruitment, both at law and in practice, and how you manage those risks. We'll talk about cases like Walker and Citibank,
sure,
where people make representations as to what your job's going to be and it turns out not to be. So this isn't about beating up the candidates. This is about trying to manage the risk as you're coming into employing someone. So that's next week. Okay. But can I just talk to you a little bit now about the case law in the 30 seconds that Karen's left me? There's a case called TAM, T-H-A-M v. Hertz, which is a case which had the usual contractual warranty in it, which warrants that your CV, your qualifications and education, everything are true and correct, and makes it very clear that a breach of that is a fundamental term and you lose your employment. That was told to this guy and he still went and lied, and they terminated him and it was successful. What I want you to get from that is, if you intentionally lie in your CV, it's not just a breach of a civil law. So it's not just serious misconduct, it's willful and deliberate. So it meets the definition under Regulation 107 of what is serious misconduct. It is a fundamental breach of a contract of employment, therefore you can terminate. Okay, willful and deliberate. But it's also a crime. So if we looked at the Caulfield Grammar principle, it warranted they had, they had education degrees and all that sort of stuff. They were charged with dishonestly obtaining a financial advantage. So it is a crime as well. I want to be very clear about that. So the processes we talk about next week, how do I check qualifications? How do I do those sort of things? Really important. But remember, the people who do this are committing crimes. And yet the level of deliberate omission and dishonesty and misleading behaviour that goes into CVs, actually often encouraged by recruiters to focus someone to get the job. Please make no mistake, if they get a job and they do not hold key criteria of that job and they deliberately lie about having that, that is a crime, okay? So we told you we'd talk about it. There's one key case, which is Tam and Hertz, but if you want more about it, we can talk more about it another time. You might like to have a look at, there's a couple of questions coming up. I'm not sure. Can you see them?
Yeah, requirement to be fully vaccinated, able to wear masks, etc., as part of the role.
Yes, there are some roles now where it's very clear. It's going to be legislated by government that's going to occur. And if you do a risk assessment and that shows, so if you're a frontline working in aged care and you were not vaccinated, it would be very hard to defend the process now. I know the union's angry about it, but that's bad luck.
Yep, and one more here. If someone's performing tasks which are mostly outside of their PD, do they have grounds to make a claim for compensation to be paid at the correct rate?
What they have, well, I mean, we've got a case on this just at the moment. The answer is no. So the answer is they do have an argument to say that their role was terminated when they're asked to do that. The problem you have is that role, say it's lesser role, this is under Cosman and Qantas. Remember a case we've talked about before. Common law, after you've done something for around about a year, that becomes your job. Doesn't matter what the job description says. So if a person's lazy, not working hard, not doing anything, and they injure themselves, the return to work is the lazy, not hard working. And if you say, well, you can't do the role which is in your PD, we're sacking you, they go, but I am doing the role I've been doing for a year and you can't terminate. So just thought I'd throw that out. Okay, let's go to the case study. So, well done. I think, yes, this is a 2-page one, so I won't make the mistake I normally make. Dale applied for a job as the CFO for Big Fish Technology. He reviewed the online PD and spoken to the recruiter. The recruiter had known Dale from his past job as it placed him there. The recruiter said the key skills were similar to his experience. He's certified accounting as an accountant and skills in industrial accounting. Dale had everything they needed. Big Fish was a fast-moving startup that created a clever app to calculate share price movement for investors. It now had capital of over 500 million and employed 1,200 people. The owners of Big Fish were school buddies, aged 30. They had no understanding of reasonable work or reasonable work behaviours. In Dale's last job, he had asked for greater flexibility in his role as a dad to his young children. That is the reason he was leaving. His role had grown and the demands were too high. The PD for Big Fish simply stated, work flexibly in fast-moving business with rapid growth driven by a CFO's skills of prediction and modelling. It seemed to be the perfect job, page 2. Both the recruiter and Dale knew he struggled with massive hours and was a gentleman with poor conflict skills. He had worked another startup called Gothware 5 years before. I made that one up this morning. For 6 months, which was a disaster. I don't know what Gothware does. They sacked him as he didn't fit into the crazy do-it-now impulsive culture. Both the recruiter and Dale agreed to omit this job from his CV. Dale was appointed in the role at Big Fish on a salary of $200,000 per annum. He loved the job for 3 months, but then as the owners sought to float the business on the stock market, their erratic and demanding behaviour started to impact his mental health. Dale explained to the owners they needed to be more systematic and their behaviour was causing him stress. After that, they isolated him and only sent emails, often at all times of the day and night, demanding he do things which lacked instructions and were objectively unreasonable. Dale put in a sick certificate to buy some breathing space. One of the owners of Big Fish had a friend at Gothware who explained they once had a CFO who did the same, and his name was Dale. The penny dropped. The owner confronted Dale over a Zoom call and Dale admitted it was him. The owner sacked him on the spot. Let's go to the poll. Whew. That was pretty racy, seeing we had a bit shortage of time there. I'm dry. Very good numbers there.
Pretty good. That's most people already. So I think another 5 seconds and we can pause and talk through it. All right, 3, 2, 1. Thanks, everyone. Let's go.
All right. So let's have a look at what we've got. So was Dale's admission of his role at Gothware sufficiently dishonest to justify summary termination? Well, can I just say at the beginning, if I had said to you, like last week, we have a stat deck where people warrant that what's in it is true in every particular, then Dale could be summarily terminated without difficulty.
Yep.
If there is a warranty that sits inside his contract, correctly drafted, then he's at risk, but not a high risk, because what he didn't do was deliberately lie. What he did do was omit something. What he said is, look, I have incredible skills. I can, in every single job I've done, I've never had trouble in this issue, and I can work all sorts of hours in an unstructured environment. If he made a deliberate misrepresentation of that fact, knowing he'd been sacked because of specific difficulties which were akin, he'd be close to summary termination.
I would have thought that throughout the interview process, Andrew, that there would have been questions around that too. And if he lied there and then also.
Well, then you go back to lying. The moment you lie, whether it's pre-employment or during employment, it's a basis of summary termination. But I think the numbers you can see show everybody's not too sure, but it's probably unlikely, and your judgment's on the money. I think it's unlikely they could summarily terminate him, certainly in the way they did.
Yep.
Okay. Does Dale have an adverse action claim? Well, he raised a safety issue, didn't he? He squarely raised it, and then their behaviour towards him changed, and it changed to the worse. So I think he definitely has an adverse action, and the termination process based on the fact that he hadn't disclosed it in such circumstances, going to his medical condition.
Yeah, absolutely.
That's the giveaway line for adverse action, and probably a very good discrimination claim as well. And he probably had a good safety argument, and he also had a good bullying argument at that stage. So I just want to raise, there's a whole series of claims that could have come out of this, a whole lot of different ways he could have had a shot at it. By the way, it's not unusual. I think we've got a question. Is that might be from Sophie to El?
No, it's from Margaret's asking, what about the responsibilities of the recruiting agent?
Yeah, well, the answer here is there's a case called Spriggs case, which puts the recruiter right in the. So they would be breaching. There'd be a duty. If you ever see recruiters' contracts, they're pretty lean, but no doubt when they make representations, which they intend to be relied on, and they are not true, they're a definite breach of competition law. Okay, so they are in strife, and it's a great question, Margaret. So always remember, competition law comes in when someone makes a misrepresentation. It's a material misrepresentation intended to be relied on, which they knew was untrue at the time. Misleading and deceptive conduct, okay? So that's what you'd go against the recruiter with. The problem is, what is the damage here? And they're actually not quite sure what the damage is, but it's still a claim. Does Dale have a workers' compensation claim? And I think nearly all of you go yes, and unquestionably it is yes, because stress-based claim has 3 defences. I'm sorry I do this to you every week. Is one, is it an injury? That's the only question you've got to ask here. Is it an injury? Because we don't have clear evidence. Is it a psychological injury? And remember, it has to be more than stress. It has to be a psychological injury to ground workers' comp. But I think that'll get over the line. Yeah. Next question is, did it arise during the course of work? Yes, it did, unquestionably, even though there may have been some pre-injury. No doubt it was exacerbated by what occurred. So yes. And the last part is, was there reasonable management action? And no, there was anything but reasonable management action. So the short answer is, it's a good claim. He's an expensive bloke. They would be, their premium would go through the roof.
And what about privacy?
Well, is it all right to talk about your medical health to somebody else? I can press the buzzer now to say no. In Victoria and New South Wales, under health records legislation, if this was an industrial area, you'd be prosecuted. I've said before that the Federal Privacy Commissioner is a cat that sits there drinking cream and does nothing. So very rarely anyone ever prosecuted federally, but on a state level they are. Do we get another question there?
Yeah, it says, how does, we just missed it. Julius, I saw your message. We'll get back to you after this.
Okay, now look, we're running to the second. It's now 11 o'clock. So thank you very much, and we'll get back to you, Julius. Thank you, everyone. It was a lot of fun today, and good to see you in the room, Karen, not the koala.
Yeah, okay. All right.
See you later.
Thanks, everyone. Bye now.